release of Nnamdi Kanu is on the table again. The unconditional release for Nnamdi Kanu is on the front burner again. It's being discussed again. In fact, just few minutes ago, this one dropped as we approach few days before 20th November, when Justice Omotosho will finally make up his mind and give a judgment on this case that has lingered since 2015. The unconditional freedom release of Nnamdi Kanu has resurfaced again. Abia State Assembly writes Tinubu seeks Kanu's unconditional release. The House of Assembly of Abia State, remember, Nnamdi Kanu is an indigenous of Abia State. They are writing President Bola Tinubu to release Nnamdi Kanu, not just to release him, but to release him without any condition, unconditionally. Let's move on. The Abia State House of Assembly has formally written to President Bola Tinubu to appeal for the unconditional release of Nnamdi Kanu, the leader of the indigenous people of Biafra. This group is writing Tinubu to release Nnamdi Kanu unconditionally. The appeal follows a resolution passed by the House on November 10, describing Kanu's prolonged detention as a matter of urgent public importance. Since Nnamdi Kanu was held, Nigeria is not moving forward. Things are not going the way it should. And they are saying that releasing Nnamdi Kanu immediately, and not just releasing him, but releasing him without any condition attached, is an urgent matter, a matter of public importance. You watching this video, do you believe that Kanu deserves to be freed? If you believe that he deserves to be freed, please come under the comment of this video and type Tinubu releasing Nnamdi Kanu now. Releasing Nnamdi Kanu unconditionally. Nnamdi Kanu must be free. Please, somebody type it. Tinubu, be man enough. Tinubu, be courageous enough. Releasing Nnamdi Kanu unconditionally. We must move on. This resolution by Abia State House of Assembly moved on the floor of the House by Right Honorable Austin Okeze Meregini, Deputy Speaker and representative of Umuahia East State Constituency, urged President Bola Tinubu to invoke Section 174, subsection C of the Constitution, which empowers the Attorney General of the Federation to enter a no prosecute and terminate criminal proceedings before judgment is delivered. Yes, before judgment is delivered on 20th of November, Tinubu can instruct the Attorney General to nullify and put a stop to this trial, and even pardon anybody. That is the power that the executive has. That's the power that the Attorney General has. That's the power that Tinubu has. Tinubu can do it. Please, somebody come under the comment and say, Tinubu, you can do it. Be man enough to release Nnamdi Kanu. Tinubu, don't be a coward. Release Nnamdi Kanu before 20th of November. Before Omotosho says something in this matter, Tinubu can order the Attorney General of the Federation, AGF, to stop this trial of Nnamdi Kanu and grant him unconditional freedom, which empowers the Attorney General of the Federation to enter a no prosecute and terminate criminal proceedings before judgment is delivered. The House also cited recent presidential pardons granted by President Bola Tinubu as precedent for compassionate intervention. Yes, recently, we talked about it here in Noble Media. Several people were pardoned. Several cases, several people were pardoned by President Bola Tinubu. They were given presidential pardon. People that are hardened criminals that deserve to be in jail. Some of them are into drugs and all the rest. Yet, Tinubu brought their names and released them, freed them, pardoned them. If Tinubu can do it for these people, why not an innocent man like Nnamdi Kanu? In the open letter to the president, the 24-member House highlighted Nnamdi Kanu's detention history, noting that he was first arrested in 2015 and detained for over 2 years before granting him bail. Kanu later fled Nigeria following a military operation at his home, which reportedly resulted in multiple deaths. In that day, Nnamdi Kanu's parents, the actions of that day led to the death of both of his parents. They came to eliminate Nnamdi Kanu. They eliminated several of his men. Young Biafrans are still missing. Some are still in detention. They released Nnamdi Kanu. Nnamdi Kanu was obeying the terms of the bail. And Tinubu, Buhari, APC-led government could not be patient enough. They went to his house to eliminate him. But God had it that Kanu was able to escape. Okay? Kanu later fled Nigeria following a military operation at his home, which reportedly resulted in multiple deaths. In 2021, he was transferred from Kenya. He was kidnapped from Kenya to Nigeria, an act the House described as a violation of his human rights and international law. It is in complete violation of Nnamdi Kanu's human rights and the law of the land. The House expressed concern over the economic and social disruptions in the Southeast, particularly citing the continued Monday sit-at-home exercises, which they linked to Kanu's detention. Please, is this sit-at-home still functioning in your area? Tell us, is the sit-at-home still functioning in your area? Tell us your state. If you are in Nigeria, if you are currently in Nigeria, please tell us. Let us know what is going on over there. Okay? Exercise which they are linked to Nnamdi Kanu's detention. The House noted that the prolonged confinement has caused severe hardship and it undermined the socio-economic development of the region. Don't forget that the whole reason for the sit-at-home is to urge the government. It's a legitimate way of pushing the government to do the right thing. The letter appeals to President Bola Tinubu to consider Nnamdi Kanu's release as a gesture of goodwill, stressing that it could contribute to peace, stability, and national reconciliation in the Southeast, because Nigeria, many people in the Southeast don't believe that they belong to Nigeria. Many people don't believe that Nigeria cares for them, so they don't even care. But releasing a man like Nnamdi Kanu will begin to heal the Southeast. The House described the release as a constructive political measure that aligns with the President's vision for a united and prosperous Nigeria. That's if the President even have that kind of vision to unite and prosper Nigeria, because Nigerians, to a large extent, from what we get, are suffering. The open letter was signed by Right Honorable Emmanuel Emerowa, Speaker of the House, Right Honorable Augustine Okeze, Deputy Speaker Honorable Uchenna Okoro, Majority Leader, and other principal officers, along with all 24 members of the House of Assembly. This is signed by Abia State. Record that the Federal High Court in Abuja on November 7 fixed November 20 for the judgment in Kanu's terrorism case. Justice James Omotosho announced the date after Kanu failed to open his defense despite being granted 6 days by the court to do so. And why did Kanu fail? Kanu has been saying, I cannot be defending myself on a law that does not exist. The way you brought me in is illegal, and the law, the Terrorism Prevention Act 2013, you are standing up, has been repealed, does not exist. It's a dead law. So there is no way I can begin to defend myself on top of illegality. The judge held that since Kanu did not take advantage of the opportunity to present his defense, he could not claim a denial of his constitutional right to a fair hearing. He had earlier filed a motion challenging his trial on the grounds that the terrorism was no longer an offense under Nigerian law. According to him, the Terrorism Prevention and Prohibition Act, under which he was charged, had been repealed. Very important, had been repealed, leaving the charges against him without a legal basis. Omotosho knows this, but Omotosho doesn't want to respond. People are asking, why is Omotosho ignoring this aspect of the law? He further urged the court to dismiss the case entirely and order his immediate release. The federal government, however, insists that Nnamdi Kanu must face trial for his alleged role in acts of terrorism and incitement linked to the proscribed IPOB movement. Meanwhile, Kanu on November 10 filed a motion before the Federal High Court, Abuja, seeking to halt the delivery of the November 20 judgment. We here in Noble Media were following this matter, so if you have not liked this video, just click on like, and if you have not subscribed and joined, click on subscribe and join, so that as we monitor this situation, you will be the first to get very active, relevant, up-to-date news flashes as they are dropping. In the motion on notice, Kanu, who appeared in person, urged the court to arrest the delivery of judgment in charge number FHC ABJ CR 383 2015, arguing that the proceedings were conducted under a repealed law and in violation of a subsisting order of the Supreme Court. He contended that the trial contravened Section 287, subsection 1 of the 1999 Constitution as amended, which mandates all courts and authorities to comply with decisions of the Supreme Court. Don't forget to type Tinubu releasing Nnamdi Kanu now, or Motosho, don't allow yourself to be used. Release an innocent man now. Kanu maintained that the Apex Court had earlier held that count 15, now not renumbered as count 7, in his charge does not exist in law. But the trial court failed to give effect to that finding. So this is the situation at the moment at the State House of Assembly. What is Enugu State House of Assembly doing? What is Ebonyi State House of Assembly doing? What is Imo State House of Assembly doing? What's Anambra State House of Assembly? What are they waiting for before they step in on this Nnamdi Kanu case? Like this video, share this video, and most importantly, click on join. There's another video on the screen. Click on it and watch now.